My name is Dustin Thompson. I'm the Volunteer and Community Outreach Coordinator with the Delaware Sierra Club. And with me today is the wonderful Ken Kristl. Ken, do you want to introduce yourself and give us a little history on the clinic?
Well, sure. And I see many familiar names and faces. Sure. So I am Ken Kristl. I'm a professor of law and the director of the Environmental and Natural Resources Law Clinic at the Delaware Law School. In terms of a history of the clinic has actually been around since 1989. My predecessor says, and I have no reason to disbelieve this, but I have no independent proof of it either, that we are the fourth oldest environmental law clinic in the world. So we've been doing this a long time. I've been doing it since, officially since July 1, 2004. And so my job is to run the clinic, which means to teach our students and to also represent the clinic's clients in various manners.
Great. So what kind of cases does the Environmental and Natural Resources Law Clinic, which I'm just going to call it the clinic from now on because that's a mouthful, what kind of cases does the clinic take on, and how many do you guys generally handle at one time?
So let me draw a little bit of a distinction because cases are a big part, but not the only part of what the clinic does. We in addition to, I think of cases, I think of some kind of litigation, some kind of a contest. There's somebody on the other side of the V. And and that's a big part. I'd probably say that that's roughly 2/3 of what the clinic does. And then we do some other things. So we tend not to think in terms of cases. We tend to think in terms of matters and clients. But in terms of cases, our primary focus is that we represent individuals and organizations that want to challenge decisions that have been made by environmental regulators, or to invoke environmental laws in connection with, say, enforcing it against someone who's violating a permit or violating the law. So our primary focus is environmental issues. And when it comes to cases, we are representing individuals and organizations that want to, push an environmental agenda by challenging particular decisions or actions in whether it's an administrative board or a court of law.
So how many are you juggling right now, would you say, in all of those kind of contexts?
So I didn't count it up this morning, but my guess is that we have approximately 20 active matters. Now, active can mean can mean different things. It's not like I'm working on 20 things every day. Some things are they don't need to be addressed today. They're still active, but for example, we might have filed our brief and now the other side has 30 days and we got to wait for their brief to come back. So I'm not particularly working on the matter during that time period. But generally, somewhere in the neighborhood of 20 to 25 matters are open at any one time. And, matters come in the door, matters go out the door. But that's roughly the number that we deal with.
That's a lot of balls in the air.
It is. It is. It is. Sometimes too many.
Yeah.
I don't know if any of you, maybe some of the people watching who have a little bit more silver in their hair, or have none, like me, can remember that there used to be, it was a very popular thing back in the 1960s where you get these people who would spin plates on a little tiny pole, and they'd have, 30 of them going at one time. And sometimes it feels like that.
I can imagine. Yeah, particularly if you have, like you just said, multiple briefs kind of coming back to you at the same time. That would be yeah, a bit stressful, I feel like. It would
It's
get
not
you,
fun.
it
It's
would
not
get
fun
you to
when
the
that
point of
happens.
more silver a lot faster.
Yep. Yep.
So how did, generally speaking, I know I'm sure every case or matter is a little bit different. I'll try to not use the word case as much.
It's okay.
So how, generally speaking, how does someone kind of reach out to see if the clinic can help? Is there like an application or kind of some central email or something?
No, there's really not a formal process. People contact me. Um, Sometimes it's by phone, which is not the most effective way in these COVID days. Most of the time it's by email. But people reach out and they're requesting some help on something, and then I go through a process whereby I try to learn more about what it is, the issue that they want to confront, and whether or not we as the clinic can help them.
So are you the one that generally makes the ultimate decision on kind of which matters you can help with, or if you
Yes.
have too many plates on the pole,
Yeah, I'm the only attorney in this operation. Um, there was a time in the past when from time to time we would have staff attorneys who work with us, but I'm it. The buck stops here, and so I'm the person who makes all those decisions.
Is there kind of like a process or kind of maybe like a mental checklist, or what generally goes into that thinking about what matters you can take on and feel comfortable with versus something that maybe you would defer to somebody else? Is it kind of, is there a certain type of project or matter that you prefer? Or is it more based on just the resources you have at the time?
Well, it's really a combination of factors. Um, First and foremost, uh, the primary mission of the clinic is to educate students by giving them the opportunity to be involved in representing clients, and to learn how to be a lawyer by actually being involved in real matters. So, one of the factors that influences my decision is this does this have the potential to be a good educational experience for students? Because if it's not, that tends to make me be less interested. It's not totally disqualifying, but that's a factor. A second factor is that the clinic is designed and is purposefully run to represent those who don't have a likelihood of having representation, right? So people who can't afford a lawyer, or uh, people who, you know, and many times there are people who call me and say, I reached out to a lawyer and they want to charge me, so much money and I can't afford that. And can you help? Right. So we tend to want to represent people who can't afford representation. And so what that factor tends to exclude are people who can. So occasionally I'll get calls from, hi, I'm a business and, I own all this stuff. And and gee, Denrec wants to sue me because I've been polluting for the last 10 years. Well, you have enough money, you can hire a lawyer. So that's a factor. A third factor is that we want to represent people who are trying to protect the environment. So it is very rare that I think I've only done it once in my 17 years so far, where I took on somebody who was sort of the polluter. And that case was a very unique case because of what Denrec had done in that case. So, but by and large, I want to represent people who you would call are the environmentalists. So that's a factor. And then obviously another factor is how full is our plate, or plates, if we're going to keep using that analogy. And, if there are times when we just cannot take on something more. And so that's, unfortunately we have to say no. And I think the last factor, and this definitely enters into, is that we do not represent people who want to sue to get damages. Um, for a couple of different reasons. One, there's usually attorneys out there who, view that as an opportunity to make money. And our goal is not to make money. Our goal is to represent people and teach students. And so we tend not to take those on. And also those cases are they're different in kind. Clients act differently when they think there's money that they're going to get out of something. And that's a client that, is different from the clients who appreciate the fact that we're trying to help them out. And so for that reason, I tend, cases like that, I tend to say, no, sorry, that's not something we'll do. So those are kind of some of the factors. And one time, one factor will be really important. Another time, another factor will be important. So, those are amongst the things that go into my thinking about it.
If you're, let's say you just have too many things in the air at the moment, is just professionally speaking, are there other kind of lawyers out there that you know of that sometimes you refer out to that may be able to help kind of community members?
Sadly, not many, especially in the state of Delaware. Delaware creates, it's just an issue getting representation simply because Delaware makes it much harder for non-Delaware attorneys to be involved. In a state like Pennsylvania, for example, and in many other states, someone who is not licensed in that state can nevertheless really sort of take over a case, provided that they have they move for and obtain what is called pro hac vice admission, right? So you have to have a Pennsylvania lawyer who sponsors you, but then you can kind of take over the case. In Delaware, you can do pro hac, but you have to pay a fee to do it, right? Right now it's $500 for every calendar year that the pro hac is active, right? So if I start representing somebody, on a pro hac, and it's $500 this year, and the case continues into January, well, it's another $500 and keeps going. And most of our cases are cases that last, 18 months to, I've got one case that's started in 2013 and is still going. So that can be a lot of money. And there's a point at which, if you pro hac too much, judges start saying, why haven't you taken the Delaware bar? That's one of the reasons why I specifically took the Delaware bar, so that avoid all that pro hac stuff and avoid those kinds of questions. But it's just kind of hard because there aren't a lot of people who do this because, it's hard to make money. If what you wanted to do is be a lawyer and make money, it's hard to do it representing the kinds of clients on the kinds of cases that we take. So fortunately, because the university is paying me to be a professor as well as the director of the clinic, it's easier for me to do that. But there's not a lot. In PA, there's a little bit more. There are some people who do various things, and I can refer some things out. But we have a very short bench when it comes to attorneys who are sort of on this side of environmental law. And if I can't take it on, sometimes clients or potential clients, it's a lot harder for them.
Yeah, I know we've all kind of seen movies or TV shows, right, where you have a lawyer coming from out of state and doing like pro bono work, and kind of, I think in some people's head that kind of gets idealized a little bit and kind of separate a little bit out from Hollywood, the reality of the situation. So just to kind of underscore and kind of highlight the importance of the work that you do, I think, it's important to note that the services that you provide for the people that you're able to help, in a lot of cases, there's not other options. So I just, it's just really great that you're able to do that.
Yeah, it also makes it hard to say no, but sometimes
sure.
you have to. So yeah.
As so you're the director of the clinic. It's kind of I think probably the best term.
That's the title.
That's okay, cool. All right. So I got it right. I know I've gotten it wrong in the past. Um, so do you kind of do most of the work, or do the students kind of have a pretty major role to play as well? What's the division of labor like, I guess, kind of generally speaking?
Well, I'm the attorney of record. And so it's my name that has to go on the pleadings. And so, I have to control the quality of what goes into it. And the structure, the way the clinic kind of operates, I mean, we do have students, they come in, but our cases tend to be much longer than a semester's worth of work. So I can't just give a case to a student and the student will take care of the case. They can't do it. Um, in all likelihood, they're going to parachute in and help work on some aspects of a case during the time that they're in the clinic. So I tend to do a lot of the work, and the students will support me. They'll do research. They may be doing some drafting, um, but yeah, I'm doing a lot of the heavy lifting.
So, I mean, I guess in terms of like, uh, as you just said, there's kind of a limitation there, given that these cases are way longer than the time the students that you serve. So I guess in terms of like the goal here being some practical experience, you definitely get some of that. So do the students ever go into the courtroom with you and kind of observe? Obviously, you have to be the one calling the shots and doing the speaking, but are they in the courtroom with you at times as well?
If we're in the courtroom, and there are students in the clinic, and those that Venn diagram is sometimes empty. But they can certainly watch. There's no limitation on that, and I strongly encourage it. I just a month ago did a trial before the Pennsylvania Environmental Hearing Board, a 3-day long trial, and I made sure that students were able to drop in and watch as much of that as they could. But the actual opportunity to step up and sort of be the advocating attorney is limited. In the state of Delaware, originally, students couldn't do that at all. And once I passed the bar, Justice Holland worked with me to amend the student practice rule to allow students in the clinic to appear before the Environmental Appeals Board. And then, of course, I haven't had any trials where students are in the clinic to do that. Okay. And, in Pennsylvania, you have to apply to get, I think it's, what is it called? Rule 371 or something like that. So there's a student, they have to be certified by the Pennsylvania court system, and then they can appear. But again, it's kind of hard if, for example, the trial that I did a month ago, that case started in September of 2018. And the students who are currently in the clinic started the clinic in January of 2021. So for somebody to come in and say, okay, well, I'm going to, appear in that trial is just kind of crazy. They don't have the background. And so it would be unfair to ask them to do that. So it's kind of hard for students to appear in court, but they participate as much as they can. And part of what I've done, in recognition of the fact that it's hard, to give students that experience, because I don't know what's going to be involved or what's going to be what's going to happen during a particular semester, right? And so part of what we do in the clinic for the educational aspect of it is we have a seminar every week, and I have the students engage in sort of a hypothetical Clean Water Act enforcement case. I give them a set of facts, I give them documents, things like that, and they have to draft a complaint in order to initiate it. They have to draft the requests to obtain discovery, like, documents from the other side, and to pose interrogatories, and to take a deposition of one of the employees of the company that they have sued. And, so that, and it follows all the way through. And at the end of the semester, the case settles and they have to draft a settlement agreement. So I can guarantee every student who takes the clinic that they will have an opportunity to practice those civil litigation skills of drafting and engaging in something like taking a deposition. So I guarantee them that. But beyond that, what students are doing is, I'm saying, listen, can you go research the following issue, because that's going to be important for us in terms of doing this in a particular case. And that's one of the things that they do. They work with me and working with clients to figure out strategy and things like that. But they're sort of playing a supporting role, which is what a young associate attorney would do in a law firm, to help me do the representation.
Yeah, I know that, I help people out in terms of testifying in committee, which I know is, on an entirely different level. But just to say it, at some point, the value of knowing what questions to ask and what to research to get everything at the end of the day, right? Whenever that time period is, that you have everything that you need when you need it, is really valuable. It's kind of like you're taking one of the probably the most major steps and giving them experience in that. And the other things you're just going to probably learn over time. Right. And I know that you had said that, the time period that you have with the students is pretty fixed and limited. So I kind of had two questions. And I also just want to mention that I'll work on bringing the questions in from the chat as well. So
okay, good. Yeah, I just saw them. So yeah.
Yeah. So, and really great questions. But since I'm the host, I get to ask mine first. So when the students are coming to you, are they at the end of their career, and after they get out of school, is it just by kind of design of the clinic, or just the way that it's worked out that you really don't get a lot of any volunteers or anything like that have went through the program to come back and give a hand to you?
Well, so the first part of your question, the students that we get tend to be in the latter half of their law school career, because they need to have certain sort of fundamentals that they've taken in their classes, right? So I will take a second year student, but most of our students over time are in their third or last year of law school. And yeah, getting people, once people leave law school, they got to worry about their career and everything else. And so it's hard to find people who would come back and help some more. So yeah, they tend to get their experience, and then they go out into the world and they're busy, trying to establish their careers and stuff like that. I have no expectation that they would want to come back and help. If there's ever people who come back and ask, can I help in some way, they tend to be people who are completely on the other end. I've been practicing law for 35 years. I'm slowing down, but I'd like to help out or something like that. So that's much more likely to be the volunteer.
So we got some great questions in the chat. So
Yeah.
I'm gonna pull these in. So Beth asked if you could describe a particularly satisfying or important / landmark case that you've been involved with, and I assume that is directed towards your work with the clinic. Although if you have something in particular, I'm sure we'd all love to hear.
I would have to say that, I practiced law for 18 years in Chicago, and I didn't have nearly the kinds of opportunities that I have running the clinic. So my important or landmark type stuff has happened in the clinic for sure. There are several that I think are important, right? And things can be important because they have a big impact for the decision itself. Other times they're important because they set or create a precedent. We've done a lot of that. In Delaware, we brought and won the first lawsuit in the nation that got a ruling which said that it was improper to plant genetically modified crops in the prime hook natural wildlife refuge without compliance with certain federal laws. They had just, sure, go ahead, plant the crops. And they had not done the appropriate environmental analyses of going into that. So that was a big precedent that we got. I have probably, whether this is a good thing or not, but I'm probably the person who has litigated the most under the Delaware Coastal Zone Act. Got some good things, got some other things that, didn't go the way I thought they should, but, I've done a lot of work to help kind of define better what the law is under that act. And from things like as seemingly silly as what is a majority of the board for purposes of making a decision. The Delaware Supreme Court actually weighed in on that one. To, an argument as to why the Crown Landing LNG terminal over in New Jersey violated the Coastal Zone Act. So things like that. We've done a lot of litigation about standing law in the state of Delaware. And I think we've kind of moved it to a place where it's easier. We went through a period of time where it was harder. There was real opposition to the kinds of clients that the clinic has, seeking, to raise questions, and standing was an easy out for these administrative boards. And I think we've kind of moved the law in a place where it's a lot harder to throw us out on standing grounds. We have to do the legwork, right? But if we do that legwork, we should be able to defeat that. And so we've had several different cases that help to kind of define that. And I think we've got some good precedent there. So those are kind of big ones in Delaware. There's several that we've sort of affected in Pennsylvania about the way Pennsylvania DEP operates. So we've had quite a few, and I am proud of those.
Yvonne, I had a question, then I'll actually come back to another question from Beth. Do you teach legislative and regulatory drafting through the clinic at all?
I don't teach it, but I do it. So we've for example, we had clients come to us who asked for help, and ultimately I say we, it's the clinic. I didn't have any students at the time, but drafted the legislation that resulted in the ban on lead paint on outdoor structures in Delaware. First state in the country to do that. We drafted that. We were involved in challenges to the regulations. They tried, they in fact did rewrite the regulations under the Coastal Zone Act, and we were actively involved in that process and challenging some of the language that was used and things of that nature. So we have engaged in that. We are currently exploring. I have students working on researching and tying this down, but I believe that there is an interpretation of the Delaware Administrative Procedures Act, which would allow citizens to request changes to regulations. In other words, it doesn't have to come from the regulatory agency itself. And if we can button that down, I think that could be a powerful tool that people will be able to use to seek to get changes to various things. So that's a process that's in the, it's sort of in progress right now. But so I don't teach it, but I do it.
I feel like we could probably just unpack what you just said about that process probably the rest of the time, but we'll maybe schedule another time for that, because that sounds pretty interesting. So Beth has kind of a broader question. It's a little bit more broad than the scope of the clinic, but it would be, if you're willing to talk about it, would be interesting to hear your point of view. And just to circle back, I think it's very fair to say that you've probably had the most touches on the coastal defending the Coastal Zone Act or litigating the Coastal Zone Act. I think that's pretty fair assessment. Anybody
I
who
think
knows that.
in recent history, that's true.
Yeah.
I think that there may be other people who, in the more distant past, had
Yeah.
more. But
Yeah.
yeah.
So her question though was, when it comes to environmental law, what do you think are the biggest problems slash loopholes slash gaps that in Delaware law that we should really be thinking about addressing?
Well, it's kind of hard to think to say, here's a specific loophole, right? I can point to some, you know, I think the Delaware Coastal Zone Act, you know, sort of, because no one was thinking about it at the time, but it really sort of left unsaid and therefore unregulated lots of things that have serious impacts on the Delaware coastal zone, right? And so, you know, and I think that it's probably the case that the idea of, oh, let's go in and amend the Coastal Zone Act is a frightening prospect for environmentalists these days in the state of Delaware, even with the composition of the legislature. So, you know, so there's some loopholes there, right? I think that, but I think probably the biggest issue, and I don't know what the solution to this is yet, right? But I think the biggest issue is that there is a certain attitude that shows up in some parts of the state more than others about how we have to sort of, you know, business wins. That, you know, when businesses complain, well, we have to take care of their interests. And when environmentalists complain, well, they're just being complainers, right? And so, and how do you break that, right? How do you sort of get out of that? And part of the reason why is because it's a tough question, right? Businesses are not inherently evil. Businesses are not inherent polluters, right? But there's a balance that should be struck, right, between their economic utility and their environmental impact, right? And I think you can strike that balance in ways that you can achieve both environmental protection and economic vitality. The problem is, I think that by and large, there's a sense in the regulator community that we don't want to, we want to stay a lot closer on the economic viability side. And if environmental stuff suffers, oh well, or we're not going to give as serious a viewpoint uh, viewpoint's not the right word, but we're not going to be as concerned about an environmental impact. Yeah, we'll make sure that the big ones don't happen, but it's the small ones that's like, you know, don't worry about that, right? And so and it happens sometimes when you know, someone comes in and says, oh, don't worry, that won't happen, or oh, that won't be a big deal, and then it's allowed to go forward and it is a big deal, right? Um, and so, you know, it's giving that benefit of the doubt, and then that benefit of the doubt works against the environment. That's a hard thing, because what you're really doing is you're changing minds, right? And I think that's the place where, and it's not going to happen overnight, but I think that's the place where we need to sort of focus some attention while using whatever legal tools we have, you know, now to protect the environment as best we can. But I think that's what has to change. And the hope is, you know, concern about things like climate change and stuff like that, to the extent that that starts to seep into things, because, say, a younger generation is so concerned about that. Maybe then we'll start to see change, but that's down the road. That's not going to happen in the next 10 years.
Yeah, we got great questions in the chat. I'm going to ask a couple more and then we'll
Sure.
pull it back a little bit more to the clinic. And just a reminder, we got a bunch of people watching over on Facebook. If you have questions, drop them in the comments, and I'm monitoring that. So Beth, in her acknowledgement of her being full of good questions today, which I concur with, brought up the Green Amendment to state constitutions that, as you know, Pennsylvania has and has been discussed in Delaware as well in various circles. So she just wanted to get your thoughts on that and how effective you felt those are, and under what circumstances do you feel, if they are, under what circumstances are they effective?
Well, I mean, I think there is something salutary about when government says you have a right to clean air or you have a right to clean water, right? That acknowledgement of that human right, I think is a wonderful, valuable thing, right? And so it accomplishes that, to have something like that enshrined in the Constitution of a state, right? But it is not a panacea. And Pennsylvania is a great example of that, right? Pennsylvania passed Article 1, Section 27, which in fact states that, everyone has a right to clean air and clean water. Pure water, I think, is the language. And expressly creates a public trust, which the government of the Commonwealth is the trustee, right? So, in all the natural resources of the Commonwealth. So that's a great thing. It was passed, at the height of the Earth Day movement, right? We're going to be celebrating Earth Day in a month. And, it was passed in 1971. The first Earth Day was 1972. It was at the height of that sort of environmental movement. And so you'd say, great, super. Well, what happened? Within 2 years, the Pennsylvania courts had sort of significantly reduced its utility, because there was a case that kind of said, well, how do we determine whether or not something violates this provision? Well, and it had this 3-part test, and the 3-part test had the effect of basically making any challenge under the amendment impossible to achieve. All right. And it took 40 plus years till 2013, when the Supreme Court in Robinson Township said, no, this really does mean something, and we need to give it some authority and some effect. Right. So then people thought, okay, well, now it's gonna solve our problems. Right. But even the Robinson Township Court said, okay, well, for example, what is clean air? What is clean water? How do we measure that? And what the court there said was, well, we've got ways of measuring that, right? Because we have regulations that are issued by DEP, and we have permits that are required by state and federal law, right? So what's the bottom line of that? Well, if I am putting pollution into a waterway, but I've got a permit to do it, that's clean water. Okay. It doesn't become, a basis to say, so the court, and the court kind of rejects, in its language, it kind of rejects the notion that, no economic activity can occur, right? Because the plant's going to produce some emissions. So doesn't that make the air less clean? Well, right. So even in that context, we have to be cognizant of the fact that it's not as absolute as we might want it to be. Our view, an environmentalist view of what clean air and clean water is going to be different than a regulator's view or the regulated community's view. All right. and it's going to fall somewhere in between there, right? So I think it's a good thing to have a green amendment, but I think we also have to sort of temper our enthusiasm about all the great things that it can do. I mean, and Pennsylvania is a really good example of that. So, it's got positive things. I'm all in favor of it. But we need to go into it with our eyes wide open.
Very much agree. So a couple more questions here. I guess one I think is maybe your personal opinion. I think we all probably.
Well, I got lots of those.
Yeah, I feel like we all have those. But the question as it reads, I'm just going to read it. Do the businesses feel they are more accountable to their stakeholders than to the general public?
I think that from the perspective, right, and right, walk a mile in the other person's shoes. From the perspective of business owners, they say, look, I don't want to violate the law, but I'm not exactly going to be, Santa Claus either, right? So I'm going to do what I have to do. But if I can get the law to be less onerous on me, well, that's what I'm going to lobby for, right? Because then I could say, but I'm complying with the law. Look, Delaware corporate law very clearly says that a corporation's ultimate loyalty is to the shareholders. And so, the fact that the shareholders come first over the general public, I think is just a natural consequence of that. Doesn't mean that they're going to say, well, let's pollute this river today. But by the same token, they're going to do what they have to do to comply, but you can't necessarily expect them to do a lot more than that. So what's the answer? Well, let's find ways to make compliance have a better effect, right? And we can get there by strengthening laws, but we can also get there by saying, look, what this law requires is more than what they're doing. And so therefore make them do more, because the law itself, without any change, requires more, right? And so, that's those are the sort of weeds we get involved in sometimes when we're litigating matters in the clinic, right? We had a case decided by the Supreme Court earlier this year, and it was about the artesian spray field down near Milton. And, they had obtained a permit in 2013 to spray on the fields because they were going to take water from a 500 home development called Elizabethtown. And they were going to treat that wastewater, and then they were going to spray it on the field. So they got a permit in 2013 to do that. Well, Elizabethtown never happened, right? So in 2017, they cut a deal with Allen Harem to take wastewater from the chicken processing plant in Harbison. And they were going to spray that on the field. Well, what happened was, in the interim, the regulations changed, okay? And the requirements that you would have to go through in order to get a permit changed. They became tougher. And so a big part of the argument was, do the old regulations to the original permit apply, or do the new regulations apply? And, Denmark had this whole argument about, well, they apply some, the new regulations apply sometimes, but they don't apply to this issue, and the Supreme Court said, no, it's the new regulations. So then we had a fight about, well, do the new regulations require what it was we wanted, which was hydraulic suitability report and a surface water assessment report, because we're very concerned that all that spraying is going to move contaminated groundwater in towards residential wells. And they interpreted the statute differently than I did. Okay, so but that's one of the ways you sort of say, look, here's the regs, here's the law, and the law requires this to be done, and they haven't done it yet, and so therefore stop them, make them do that. That's another way to get at that.
So we had another question from this one from Willie Scott. Have you seen a state or municipality that could serve as a model for addressing the types of environmental justice issues we face in Delaware? And he mentioned a couple of particular issues, or one particular issue, which is the proximity of industrial and heavy zoning and residential zoning.
Yeah, Willie, I work with Willie. I wish I could point you to someplace. I mean, what happens is that you see sort of sporadic efforts, right? You've seen it at the federal level, right? There were efforts to emphasize EJ during the Obama administration, and all those things were folded up and packed away, and tried to bury under 20 feet of dirt in the Trump administration. I think you're going to see some of that come back. From time to time, states and local municipalities, say, gee, we really need to address this issue. What we haven't seen is a sustained long-term effort yet. And as a matter of fact, one of the issues for law school environmental clinics across the country is, what can we do to move that needle? And people are trying to do that by pushing issues more. And part of it is we've got to find creative ways. There's an environmental law clinic down at Tulane, and they represent people who are in the Louisiana Bayou, all those chemical plants, all those refineries. That is an EJ alley of significant proportion. And they've come up with some strategies or some approaches, usually through challenging permits, that have gotten some results, some EJ results, right? But you kind of wish that there was a little bit more support for that at the governmental level. And I haven't seen a lot of sustained effort in that regard, sadly.
So I got one for you myself, and then we'll get to Yvonne and get to our last question here, probably wrap it up. Actually, we got one on Facebook I'll bring in real quick. What role do you feel like the fees assessed by DNREC and other enforcers play a role in kind of the behavior of industry? Insofar, I know there's a number of fees that have been levied on industries lately that to the public and I think to environmentalists, which I'll just frame that I don't think environmentalists would ever feel that any fee is high enough, but certainly, you look at some of the dollar amounts that are being levied against certain industries in Delaware that are polluting on a pretty regular basis. And it seems like it's kind of a slap on the wrist, and one that hasn't been adjusted in a long time. So I'd love to get kind of your point of view on that, and if you think that plays a role in the continued issues that we see from some of these entities.
Sure. So, the purpose of fines, right, is to, in effect, force, economically incentivize compliance, right? And in Delaware, there are two unique issues, right? Issue number one is that the vast majority of the fines in the environmental statutes were put into the statutes in the 70s and in the 80s, right? And so, in 1981, a fine up to $50,000, meant a lot more than what $50,000 does in 2021, right? So that inflation over time has degraded that deterrent effect that those penalty amounts have, right? And so there's, I think, a need to push for an update, if nothing else, to just capture that cost of living, that inflation adjustment, to keep that level of deterrence around, right? The federal law, federal government back in 1991 passed a statute which required that all of the fines be adjusted for inflation every year, right? So if you look at the Clean Water Act, the statutory language says that it's up to $25,000 per violation. But because of the the Inflation Adjustment Act of 1991, that actual amount now is $38,500 because they've been adjusting it over time, right? So one of them is we need to sort of modernize and update the numbers. The other problem is that most of the time in the state of Delaware, those fines are administrative in nature, issued by DENREC. And the statutes limit DENREC's ability to do those fines in a very concrete way. They basically limit the fine on a per day basis, regardless of the number of violations. Okay. So I could, I could have my chemical plant blow up and have 10 different violations that occur on the day, but DENREC is limited in its ability to assess those fines to one fine for that day. Okay. So we need to empower DENREC to be able to say, that's a violation, that's a violation, that's a violation. Each of those are up to the statutory amount. And that will also create some more deterrent effect. Now, you also have to have a secretary who's willing to pull that trigger, right? But nevertheless, we have to untie the secretary's hands. So I think those are two big things in Delaware that limit that ability.
All right, environmental advocates, you heard our call to order here. So I got one more from Facebook, kind of a general question, and then I'm going to pull it back to wrap it up on the clinic. And really appreciate you taking these deep dives, kind of a little bit off the beaten path here today. So we have Bill asked from Facebook if you're working on any Coastal Zone Act issues right now.
Yes. Amazingly, we have pending a case that we filed in 2017. It was a challenge to a Coastal Zone Act permit that was issued to the Delaware City Refinery that would allow them to bulk transfer ethanol, bring it into the facility, load it on the barges, send it up the river to other refineries along the Delaware River. We challenged that in 2017. The Coastal Zone Industrial Control Board threw it out on standing grounds. We appealed that. The Superior Court reversed the decision, remanded it back to the board. It took more than a year for the board to meet before it could deal with the remand. And in the remand, they ruled 4-3, yes, we have standing. That was in January of 2019. We are still waiting to go forward with the next step in that proceeding. So yes, we still have that pending.
Which speaks to the fact that these are often long cases.
Yep, exactly.
So we had two more questions on the clinic. It's to get back to the clinic itself. Yvonne asked if, and I'm hoping pronouncing your name correctly. Do you work in cooperation with environmental groups or just with individuals?
Both. We have some longstanding clients who are different organizations. In the past, we've worked with Sierra Club, Audubon. We're doing a lot of work right now with Food and Water Watch, the Socially Responsible Agriculture Project, SRAP. We work with them. So lots of groups, right, who come to us with issues. But also, we have individuals who are like, hey, they're going to build this thing in my backyard. Can you help us? Right. And so we've represented, and whether it's an individual or whether it's a group of people who together sort of, have kind of a common interest in sort of challenging a thing, we'll take that on. So we represent both.
And so the last question I'll pull in and we'll wrap it up here. What are the costs kind of associated with to the groups or individuals that you represent? Obviously, if they go through a private firm, they're going to likely pay out the nose for legal representation, plus all the administrative fees and court fees and all that sort of
Right.
impacts. How does that work with the clinic?
So we do not charge for attorney time, right? So it's pro bono legal representation. But what we do ask is that to the extent that there are costs, that clients pay those costs. Now, many times those costs are a filing fee or something like that. So it's not necessarily a lot, but it can be. You want to hire an expert, experts cost money. We do not have, at the present time, the clinic doesn't have the luxury of funds available to do that. So we ask clients to sort of bear that cost, but that cost would never be incurred without consultation and agreement by the client. All right. So we might say, look, an expert would help us out here. Be really good to have them, but it'll cost you, $5,000. And people say, we can't afford $5,000. Okay, then we won't use the expert. Okay, we'll have to find another way to argue the case. So we work closely with the clients on that, but I'm not going to charge. And if we're in a situation where we actually can recover fees, and there are some, the federal environmental statutes allow that, but for example, in Pennsylvania, if we're challenging something under the Clean Streams law, if you win, you get your attorney's fees. In that scenario, we ask the client to agree that if that happens, we can submit a request for fees for our time, and we get that money, we get to keep it, right? But we're not gonna tag people or try to charge them for fees.
Great. Well, I appreciate you jumping on. Furthermore, I really appreciate the work that you and the clinic do for the environmental movement and for the communities that otherwise, as you stated earlier, likely would not have the mechanisms for recourse and the resources that you at the clinic and the students there provide. So, hats off to you, sir, and the work that you're doing. And I appreciate everybody who signed on today and joined up. Second, Yvonne, admirable. Beth, your state treasurer, getting lots of love in the chat there.
I also did want to answer one of the questions here near the end, which sure. So the law can never be clear. Yeah. No, sometimes the law is clear, and sometimes ambiguity is what lawyers love, because then that means we get to argue about it. But there are times when the law is very, very clear, and people will. That trial that I did a month ago, to me, the law is obvious, and you would not believe the contortions that DEP and the developer in that case went through to avoid what that law requires. So I'm hoping the judge sees it that way too. But sometimes it is clear. And when it's not, that's what we're here for, to argue for the interpretation that makes the most sense.
That's where you hang your hat. So
I like to do it. It's fun.
So, all right, great. Well, thank you everybody for hanging in there. Ken, thank you so much for your time and for the work that you're doing. We really appreciate it. Everybody who maybe jumped on a few minutes late, this in about 5 minutes, this will be up on Facebook permanently, so you can go back and kind of watch what you missed. And we'll get it up on YouTube soon for everybody else. So thank you very much, everybody, and thank you for your time. We'll be back next week to talk about managed retreat from climate change in Delaware. So another very interesting topic coming up next Friday at 3 o'clock. It'll be up on our website on the main page here within a couple hours. So definitely RSVP for that one with AR Siders from the University of Delaware. Thank you very much, everybody. Have a good day and a good weekend.
Bye-bye.